Hi everyone, can you all hear me? Great. So I would request now that we give just 5 minutes for the rest of the attendees to join the meeting, and then we start officially at 9:10, if that is okay with everyone, because I see there's still a lot more joining in. Karibuni sana. I can't all wait to have this conversation with you. Hello. Good morning once again. My name is Josephine Wawira from Conversations with Wandi. It is my pleasure to be hosting you today. For those who are our first-time attendees, we welcome you so much to Conversations with Wandi, where we have monthly conversations on matters regarding human resources. This will be our first panel discussion, and we are excited to have two panelists with us, Judy Ndegwa and Christopher Okech, whom our host Wandi Karingi will be introducing in a few minutes. So karibuni for those who are still joining us. Remember, you can follow us on our pages, social media at Conversations with Wandi, and we are also live on Facebook where you can follow the conversation as well and share the link with your friends and connections to follow this conversation. So we are excited today to be speaking about employment laws of Kenya, and we want to share things that you must know. And this is where you're going to find how to use employment laws to the optimal for you as an employee, as an employer, or other interested parties. So Wandi will be sharing with us our learning objectives for this day. Once again, we are excited, and allow me to take no further time and to introduce Wandera Karingi, our usual host for Conversations with Wandi. Karibu sana Wandera, so that you can introduce yourself to our new members, as well as introduce our panelists for today.
Alrighty, thank you, Justin, very much. Once again, I just want to thank everybody that has joined us. For our loyalists, we are very grateful to have you again. And for the people who are joining us for the first time, welcome to Conversations with Wandi. My name is Wandera Kweyu, and I'm going to be your host for this particular webinar. I would like to remind all of us to like and follow our pages on Facebook, on Twitter, on LinkedIn at Conversations with Wandi. Today, I'm very delighted to be joined by two very special people to me and also to the practice within which we operate. I would go with ladies first and introduce Judy Ndegwa. Judy Ndegwa is a HR practitioner that has been in the business for quite a long time, a decade plus. Judy has been performing very more skewed towards labor relations and industrial practices within the HR field. And she's a completely interesting resource to have here today to give us a practical view of human resource management in regards to law. Thank you very much, Judy, and Karibu. I would like to also take this opportunity to welcome Chris Okech. Chris is an advocate of the High Court and also a practicing advocate currently. He has extensive experience in commercial laws and including labor. Chris will be a very good resource today to give us a view into how the laws operate when you are now on the other side in courts as we are working through this process. Thank you very much, Okech, for joining. Asante. And we are also very grateful for all of you for joining. We appreciate your time. And now we are just going to jump into the process of this particular webinar. For the sake of those that are new, we in this webinars take a short time to just give you a synopsis of how the laws are operating. And then when you go, once we complete the webinar, we have a takeaway package for you. This takeaway package will have very detailed explanations on the laws and how they operate for you in the workplace. So please don't worry when we rush through things. You can be able to read them later at your own time. In the event that you have any questions, you can type on our question and answer chat box for now, and then we'll be able to answer those questions for you as we are proceeding. Without much further ado, welcome to Employment Laws of Kenya, what you should know. And I just want to start this conversation by saying that you are not alone if you don't know where to find the laws of Kenya. You're not alone if you don't know where to find all the laws of Kenya with regards to employment. And that's why today we want to give Chris some minutes to explain to us where we can find these laws in a wholesome way within the employment sector. Okay, Karibu.
Good morning, guys. As per our slide, we had prepared slides. Give us a few minutes as we try and put those. Now, as I believe you can see now, sources of law include statutes, which are basically acts of parliament.
Christopher, perhaps you can check on the echo, as it's a bit too much.
That is being sorted as we speak. Is it better now? Good. Now, as you can see on your screen, the first source of law for employment are statutes. These are acts of parliament, which are, of course, practically bills that govern, with written bills and laws that govern the relations between employees and employers. They cover the basic relations and rules and guides and so far. And some of these, the most of them are actually usually enacted through parliamentary processes. They go through assent by Parliament and then signing into law by the President. The most of these are the Employment Act. The most important of these is the Employment Act, which is the most important guiding law for employers and employees. Then after that, there comes in the Labor Institutions Act. This one generally regulates the relationships between both employers and employees, and also goes as far as to also speak about the general work environment and stuff. Then there's the labor relations, labor institutions, Occupational Safety and Health Act, the Work Injury Benefits Act. This one's all take us nicely through the. Now, sorry for the mix up. Now, I'll go back to the slide. As you can see from our slide, the first source is statutory laws. These are the laws and codes of law that are enacted in Parliament. The second source is exclusions. These are generally one second. Sorry, I'm mixing up my material here. Sorry, 1 second. I am mixing up my material.
As Okech is
Please unmute yourself, Wandera.
Sorry, as Okech is still checking up on his materials, the exclusions that he was talking about are the exclusions that are contained in the statutes that we have. And these statutes have prescribed some articles of law that we are supposed to use. For example, if you read the Employment Act on section 35, it provides for service pay. But then again, there is some things that it has excluded for people to be able to get that service pay. So if you are participating in any recognized pension or provident fund that is recognized by the Retirement Benefit Authority, you're actually exempted as an employer from paying service pay. Now that we have Okech back, he can take us through the associated legislations.
Now, let me just myself.
So Okech is unmuting as he gets a hold of this.
Yes. Now, second bit of this conversation is these are the associated legislations, and these ones include the Employment Act, the Constitution, and of course we all know these ones cover rights of employees in terms of right to a salary, yes, right to a good working environment, right for fair pay, and all that stuff. The second category of associated laws are the international laws. And these ones are mostly tied to labor institutions, international ones. Yes. Now, the third category these are best practices, yeah? And these are generally the standards and practices that we as employees and employers are put in practice through our codes of conduct, our sexual harassment policies, our disciplinary processes, and whatnot. Now, the fifth category, these are internal regulations. Again, these ones will be the employee handbooks, the disciplinary processes, and what have you. Now, we all realize that based on some certain skills and sectors, there are usually member associations which are like unions, which now collectively help members bargain for some rights. And this is like now, let's assume we can actually give an example where Code 2 in Kenya and the Teacher Service Commission, which now help the teachers negotiate for their rights. Now, the final source of law are case law. These are what lawyers, we call them loosely precedents or decided cases. And for purposes of this conversation, we can actually now give you an example where sometimes there's a dispute, and we will find that this dispute is not necessarily one that is found in laws per se. So usually parties will go to court, litigate, and a court of law will rule on this particular item. So this, with time, now become guides for such disputes, and actually are now with time become widely accepted. And this is both in terms of local laws and even international cases, where sometimes we have cases and issues go through international court. And after that, I think I'll hand over to Josephine and Wendy to take us through the next stage of the webinar.
Okay, thank you very much for the very clear explanation. Just for purposes of recap, the laws of Kenya are contained in our statutory, our statutes. Within the takeaway package that you will get to see all the statutes that we have put in place. We will also see the exclusions that are included within those statutes, our associated legislations like the Constitution, the International Labour Organization, among others. We'll also see the best practices that are available within the different sectors of practice. We also have our internal regulations, our membership organizations, and case law. As we are going through this conversation today, we are going to dive deep into this particular type of into these particular areas that we have discussed, just to be able to see how they come alive in the things that we do every day. And without much further ado, let me get Judy to tell us a little bit about what are the best practices nationally and internationally when it comes to labor laws in Kenya. Judy, feel very welcome, and let's have fun with this.
Thank you, Wendy. It's a pleasure for me to join the conversations with Wendy. The first time I attended your session, I was an attendee, and today I'm a panelist. So truly appreciate seeing you giving me this opportunity. As it had been mentioned earlier, my name is Judy Ndegwa. I'm a HR practitioner. And I'll be taking you through the best practice, as Chris has taken through us the sources of law, which will include the best practices that I'll dive into. And looking at the best practices, we are looking at anything that is above minimum requirements, whether it's from an international requirement, like the sources of law from international institutions like higher law, and also locally from our Employment Act, and also companies that come up with very good practices that go beyond what the law requires. So I remember there's one person I sent this link, and they asked me, Judy, are you guys going to go through the entire Employment Act? And they'll say it's very expansive. So how we have done this is putting the best practice in different buckets. So as you can see in your screen, there are 5 buckets, which I'll speak through in each of the buckets where best practice can be taken from. So we'll start off from discrimination. And anyone who's ever gone through social audits can clearly remember that, besides the minimum requirement that is required by law, where you find it in Employment Act Clause 5, then there's always more when it comes to recruitment. Are you discriminating in terms of pregnancy or sexes and all that? And all those things can be put in the employee handbook, where you want to have more than what is required in the international labor laws or the local labor laws. The other one is on harassment and bullying, where you have, there's the sexual harassment, which is described in the Employment Act, but there's no act that talks about harassment. And this reminds me, the other day I'm in a group where I saw someone asking, when a senior leader, abuses you or uses very profane language on you, then which act do you run into? We don't have that, unfortunately, but coming from best practice, have policies in your handbook that address those issues. Talking about what happens, when someone is bullied. It can be the line manager, bullying the other staff, or the other staff, bullying the senior managers. Then your local handbook or employee handbook should address the same. Issues to do with child labor. Just coming to the next slide. So issues to do with child labor, and I combine that with slavery and servitude. And the Employment Act, defines what form of child labor, what child labor is about. If you go to the Employment Act, then, in the definition sections, then it will give you what that means, in terms of using children, anyone who's under the age of 18, in drug trafficking, in factories, in places where, kids are forced to, go into war. There's some countries where, kids are taken into war, and it's part of, child labor or slavery. If we go to the second bucket on sourcing and contracting, best practices should come from, how are you protecting data for your employees? And I've seen in a number of recruitment platforms where they ask you to put in data. So, you don't ask yourself at that point, looking for a job, you just put in your data, date of birth, ID. Do you ask yourself what happens to that data? And I'm happy to say that, the protection data laws are there. So if an employer uses that data for any other purposes besides what is required for recruitment, then you're in a position, to pursue that and say, what are you doing with my data? And I'm happy to say also there are some companies that are already forward in that area, where now when you're putting in your data, there's a consent where say, I agree my information to be used for recruitment purposes only. In terms of occasion in writing all contracts past 60 days. So that's the other area where, I think most of us as HR practitioners, once you do the offer, you're like, I've just, hired someone. And you forget about that. You need to actually do a document that has the details of, what is the, terms of employment. And you see that in the pocket guide that will be shared with you later, the things that should be in that written document. When it comes to ensuring legality when hiring foreigners, the employers who hire foreigners should be very conversant with the legal matters that goes with hiring foreigners. Are you doing a special pass? Are you doing a work permit? Is it a valid work permit? Because sometimes you get work permits that are not valid. So you ask yourself, in terms of best practice, before you bring in someone from the outside the confines of Kenya, do they have a valid work permit? Is a special pass still, within the expiry duration? So you have that as one of the best practices also. The third bucket there, we have performance management. And a lot of companies now have embraced the idea of having a performance management system, because most of the time you have issues that come from, performance, poor performance, and it's because of lack of having a performance management system where, if you have an employer who says, I feel Judy is not at the level where she's supposed to be at. I feel Judy. So it becomes a matter of feeling, I like, I don't like. So when you have a performance management system, then that is able now to give the transparency to the employees. The employees also need, they're able to track their performance. Are they doing well? Are they off track? Are they on track? Then that helps a lot. So the companies that don't have performance management system, they should look into that. And it doesn't have to be very expensive. You can have an internal, if you're not a big number of employees, you can have an Excel that can do that tracking. It's a little bit manual, but if you have a big number of employees, you rather invest in having a performance management system. And there are many local companies that are providing that kind of service. In terms of onboard employees on the system, because you don't have the system, just being there are good to have. You also need to have conversations with employees. As an employee, then am I looking into my performance? Am I going to say 10 years I was in this company, I never became senior or I never grew in terms of professional career levels? Then I need to ensure that I'm embracing that system. In terms of being clear and handling poor performance, and this is where you have some of the litigation issues. Do you have a PIP system in place? Do you have a PIP policy in place that will help you guide in terms of poor performance? And some of the times when you have conversation with employees and tell them that I'm putting on a PIP, some take it as as a death sentence. And I always say that's not a death sentence. And it's unfortunate the perception is like that, but it's purposely for improving, and that's what it's called a performance improvement plan. So we say in the next 6 months or 3 months, Judy, I need you to, ensure that your Excel is at this level. Judy, I need you to ensure that your sales are at this level. So you're improving yourself. But if as an employee I go into the fact that, I'm being stabbed with a PIP and, this is the end of me and my life, then of course I will not work through those improvements I'm supposed to be having. The other one is on the having policies that you drive them through consistently from all areas of different levels in the company. So that you don't have, setting precedents that, Judy was given, a good performance appraisal, but then when Judy is working at the factory, and then you have Chris here working in senior management, and then the way he's treated in the performance management process is totally different from it. So the policies should be quite consistent so that there's fairness, there's equity, there's transparency on the same. And one important thing, which is at the last of that bucket, the point there, is allowing for dispute resolutions and appeal. And I remember a few days ago in one of the platforms I am in, we were talking about what happened to ADR, what happened to the alternate dispute resolution mechanism, because most of the time, when an employee is gotten into performance management issues, then, you're taken through PIP and then you're told you're terminated or the summary dismissal. Then what policies do you have to ensure that there's, allowance for dispute resolutions? You always don't have to go the hard way, quote unquote. You can sit down, have negotiations. If, someone said that I was having a hard time, then, how do you then bring them up to speed to the level where they're supposed to be at? The fourth bucket is about discipline. Having policies around discipline, and the Employment Act is very clear that it gives a guideline, what constitutes discipline, on clause 12(1)(a). So you can look into that. I don't want to delve into it, but just have a, what does your policy say in terms of how to handle discipline and grievances. The other thing is for having employees to have representation, and a number of companies, unfortunately, kind of ignore that bit. But best practice talks about, let the employee, if you're going to a disciplinary hearing, let the employee bring in a witness, and sometimes you have employees who, bring in a lawyer. So you're there seated and then they walk in with a lawyer. So say Chris here comes and starts talking about jurisprudence, and you're there like, I have no idea what that means. But so the thing here is that when you have best practice, tell the employees, yes, bring a witness, but don't bring a lawyer. And give the reasons why they should not bring a lawyer. Because what I mean, if we bring a lawyer, then we also, the employer will bring a lawyer. But we are not at that level where, we're going straight into litigation. It's a matter of having a hearing that is fair, that is transparent. The witness can chip in and, give information that will help in that process. We had talked about applying policy consistently, still applies in discipline, documentation. And I need to just emphasize on that. Even as an employee, when you go into a disciplinary hearing, ask for that documentation. It is your information that is being captured there, so that when it comes to whatever decision is being made at the end of the disciplinary hearing, then you can also confirm, this is what I say, this is what I mentioned in disciplinary hearing. The same thing on the employer side. When you have this documentation, it helps so that, when you go back to it and do reference, you can actually check and say, we did this as per the process, the document is here. And it's purely not for the purposes of saying, let's go to court and I'll produce all my, documents, just to prove that the person is guilty. That's not the intention. It's having documentation that, to be put in the file, someone can always come into reference to it. And finally, having appeal, again, as said, and most companies forget about having a policy on appealing procedure. That is highly recommended. If I'm being told, Judy, for example, took something from the factory or from the office, can I appeal regarding the same? And this doesn't have to go through the entire disciplinary case again, where you start from scratch. There can be conversation where the policy guidance says, if there's an appeal, then certain people will sit in that appeal hearing and the procedure, and then the steps for the same. Of course, being confidential in the process, and employees appreciate that. I am an employee, so everything that I say or I treat other people, I always put myself in their shoes. I'm an employee, I can be in the same shoes if I'm being summoned for something. And, always don't look at, for the times I've been doing disciplinary hearings that, those are those people and me and I'm part of management. No, it doesn't go like that. It's part of, having respect for the person, treating them with dignity, whether they're still or not, they're human beings at the end of the day. And finally, on the final bucket on termination, which is one of the areas where, it's really heated when it comes to companies that don't have best practices on the same. So have valid reasons. We talk about unfair dismissal is when you breach substantive law. And there are two ways of treating fairness. Fairness can be categorized into two ways: substantive fairness and procedural fairness. So the Employment Act also, refers to Clause 41 talks about, 41.1 grounds for termination, and the examples that are highlighted there, incapacity, poor performance. Nowadays we have mental wellness, and a while back, the grounds for termination could be, someone cannot stand for long, they cannot sit for long, behind the computers. But nowadays we have mental issues going on. How do you deal with that? And I remember there's a case where, a certain employee kept on forgetting they had dementia. What do you do with that? They're not pretending. At the point you think they're pretending, covering for self. Were you supposed to do this? Yes. Do you remember? No. Those kind of things. So then how do you have best practices that does not only look at physical incapacity, but also wellness, mental wellness? I talked about fair process, fairness in terms of the employee, fairness in terms of the employer. That constitutes of best practice. Also acting in good faith, where you have the natural justice. And I talked about, treating everyone with dignity, respect at the end of the day. As much as whatever happened in the disciplinary hearing or whatever issue has been brought through, let the person who's being asked to, to explain themselves, that are being given a show cause, come out of that room with their head high, holding their head high, not because they did something or they stole or etc., but give them that dignity, they're human beings. And then finally, on paying dues to the employees, there's always a concern about that. Have best practices where, by the time the person, let's say there's a summary dismissal, work with finance, work with payroll. And for me, one of the things I've discovered is as a HR practitioner, partnering with finance, partnering with the other functions that, you know, complement each other. So if you're talking about paying dues of an employee who's been summarily dismissed, then, you know, how do you fast track that? You don't say, oh, by the way, we closed payroll, so wait until next month. Remember, this person is going through emotional turmoil. You need to still treat them as human beings. So work with payroll specialists. If it's just a click of a button for them to ensure that, you know, the final dues are done within not more than like 2 weeks, then do that. And just, you know, partnering with the different functions, whether it is security, you know, if they, you know, they need to pick something, they need to return something, a laptop or you know, PPEs, if they work in the factory, then that's part of the, you know, ensuring that the dues are paid and it is done well. So I'll give it back to Wendy to pick it up from there.
Wow, Judy, thank you very much for the expansive and elaborate explanation that we got there. So at this point, I'm feeling excited. I'm liking the questions that are coming up on the chat. I see that now we have known where to get our laws and we've known what is best practice. So the question is, how do these laws come alive? How do you see them working for you every day within the organizational setup? I want to acknowledge the questions from Masha Mushiri. Thank you very much on your question regarding adoption law, and we will talk about that one as we continue within the process. Jacinta Kisungu, thank you very much for the question on performance management that has been answered in text for you. I see Josephine Muburi, Joseph Kibe, Damaris Ndugwa, and Emily Kinuthia. You have all given us some questions, and Emily Kinuthia's is a comment on the insights that they have received from Judy. They think that's very great. Judy, thank you very much for that particular issue. Now, when we are looking at the laws coming alive, what do we mean? What do we say when we are thinking about laws coming alive? This is mainly encompassed in situations where you have known the abstract concept. You have seen, they've said, Employment Act says, you've seen Constitution has said, somebody has mentioned 1 or 3 things about ILO, but how do they relate to you as an employer, to you as an employee? Let me take some minutes to just walk through this as we answer the questions that have been raised here today. Now, how do these employment laws come into function for you? Now, I've put it into a few ways. Let's call it like employee work service. How do they go through? How do they work for you within an organizational setup? So imagine you are starting to look for a job. How does that work for you throughout the process up until when you get the job, you're in the company and you've left the company, and what happens to you after you have left the company? Question number one, thing number one is when we are sourcing, and I'm going to talk about both sides of the divide, or the employers, employees, and other players within the area. So when you're sourcing, what are those things that you need to be able to keep in mind, the things that have been legislated as you're working on your proper processes to be legally compliant as an employer or an employee? Thing number one, your background checks. There is no law, no specific law currently that says you cannot do background checks. However, there are quite a lot of laws on issues of privacy and specificity on the kind of information you should be getting. Ladies and gentlemen, I'd like to tell you that when you're seeking to know the background of somebody for purposes of employment, it really should be confined into the purposes, into the work context in terms of background checks. So those background checks that you do and ask, is this person really married? Do they really have 3 kids? What kind of family do they come from? What kind of ethnicity politically do they have? Among other things, those are actually prohibited. And the information that you get, if you're going to use it, is going to end up being discriminatory anyway. Second thing is your medical checkups. Ladies and gentlemen, the key of this is to ensure that you don't ask for medical checkups unless these medical checks are 100% required for the particular employment that you're getting. Furthermore, even if they are required, no employer should have your medical history. What is the situation is that this employer should be able to receive what we call a certificate of fitness. It should just say that Wandera has been examined in our clinic and we have found her to be fit for the role that I have explained, or we have found her not to be fit for the role that is on offer. No employer should require you to give them your medical certificate, your medical history. So employers, remember what you're getting is the certificate of fitness. Employees, remember what they should be getting is not your medical history. When it comes to application data, when you've been able to get somebody's telephone number, their email address, maybe sometimes their residence, among other things, please do not use this information for any other purpose other than for employing them. Once the process of recruitment has completed, this data should be stored on the side and not given to any other person. So employers, here I'm talking about the people who give these people to these numbers, especially telephone numbers, to promotional services to get promotional messages. That is not allowed within the law. I'm also talking to employers, especially in employment agencies, where you're sharing people's data with other of your colleagues. Don't do that without their consent. In fact, there is a very nice way through the systems and the mechanisms of applicant tracking systems, where you can put a little question there, you know, the tick box that say, I have given you permission to share my data with other people for purposes of job seeking. If you do not have that, do not share people's data. When it comes to preferential hiring and discrimination, quite a number of people are a bit confused on what is discrimination and what is preferential hiring. Discrimination is when you take something that is protected. So that is somebody's health status, somebody's mental status, somebody's physical capacity, somebody's association, among other things, and you use that as the premise to deny them a job, then that becomes discrimination. However, when you hire somebody because they have better skill, they have better capacity, they have better experience, and they are more grounded in what you're looking for and fits in your company culture, that is preferential hiring. When your job requires somebody to be able to sit in front of a computer every day and type in, and you don't own any braille type computers, you can say, for instance, a person that is visually impaired will not be able to get this, to be able to function with this job. So then that becomes preferential hiring and not discrimination. Ladies and gentlemen, if somebody comes into your employment, seeking for employment for you, do not ask them if they are pregnant. Do not discriminate against them if they are pregnant, even if they are visibly pregnant, unless this person offers you and says, I, Wandera, is pregnant. Do not ask those questions. They are discriminatory. When you finished all of this and you're coming into contracting, how do we contract? Employers, employees, I'm talking to you right now, just have an open mind and hear me out. Simply because you have written in somebody's contract, consultant, and you're paying withholding tax does not preclude the courts from reclassifying that person as an employee. How can that person be an employee even if their contract says that they are consultants? Number one, what is the control mechanisms? Who controls them? Who tells them where to be, what time to be there, what to do, how to do what it is that you're saying that they're doing? So if their supervisor is within the organization, they are following the process, the timelines of the organization, the dress code of the organization, etc., that person is controlled by the organization. If that person has been integrated in the organization to the levels that they are part and parcel of it, like they are part and parcel to the disciplinary processes and procedures, they are part and parcel to the pay process that is within the organization, they are part and parcel to accepting and or declining their anti-discriminatory policies, their equity hiring principles, that person has been properly integrated into the organization. We also look at, is that person an entrepreneur? The question is, are they ultimately responsible for their own profit and loss? Do they bear the full responsibility of that? When they don't, these people are employees. Lastly, which type of taxes are they paying? Are they paying PAYE? Are they paying withholding? Are they receiving benefits like leave, housing allowance? Are you giving them food? Are you giving them water? They are tools of trade. Where are they coming from? If you have answered yes to any of those questions, irrespective of whether or not you have said this person is a consultant, they are an employee. So ladies and gentlemen, please consider all of these things as you're making the contracts that you're having. I also just want to mention that contracts with employment agencies need to be very specific so that they don't end up requalifying people that are employed by other people as your employees. So what do you do in these situations? Make sure that the contracts they have are authored by the employing person. The disciplinary procedures, performance management, termination, salary payment, they are all done by this particular employer. For you, they should just come to deliver a service and go back to their own employer. There are very specific contracts must-haves according to the law. We have that, I think, on Section 10 of our Employment Act that gives you the details of the person, the job, the details of the job, the responsibilities of the employer, the responsibility of the employees, gives you purposes on disciplinary hearings, termination, notices, and etc. Don't worry, ladies and gentlemen, this will be provided for you in full detailed point form in the pocket, in your pocket guide for employment laws of Kenya. When it comes to probation, probation is only allowed for a maximum period of 12 months. How is this maximum period broken into? When you hire somebody on a probationary contract, it can be only for a period of 6 months and not more. After those 6 months, you can extend it one more time for a period up to a maximum of 6 months. Anything else is now beyond that. Foreign workers, if any person is staying in the country for more than 185 days, according to our Income Tax Act, they should be liable to pay taxes. If this person is deriving income from Kenya or their income is accrued in Kenya, they should be able to register properly so that they can work within the country. If this person is currently working with a legal person who is registered in Kenya, then they need to have proper registration to work with the country, within the country. So we have people who have the special passes. These are passes that can be extended for a maximum of 6 months to ensure that you are able to participate properly in the seeking of your valid papers, and that is your work permit. In terms of the terms of service, there are statutory minimums that have been put for you. You need to make sure that you have them. I just want to mention, of course, your working hours, your overtime, and all the other mandatory employee benefits. Like I had said clearly, we have given you in your pocket guide all these things in very good detail. You can be able to see them. Now, on your payslip, what are the allowable deductions? Of course, those are your taxes. Of course, those are your statutory deductions, other statutory deductions like NSSF, NHIF. Of course, there is those things that are owed to the employer, or the other deductions like maybe SACCO, bank check of loans, and all these things. The key to these particular deductions is to know that if somebody earns 30,000 Kenya shillings per month, this deduction should not be more than 20,000 on their salary. And I mean it on the gross, it's not on the net. Because the moment you do anything like that, you have automatically breached the law. Pay should be given on a work day, during, within the premises of work, and if the premises of work are in the state that there is intoxicated alcohol or other drugs within the area, you're supposed to pay them outside of that particular process. Now, the second thing is on the termination of employment, make sure that your grounds are solid, give notices where you're dismissing on grounds that are not gross misconduct, make sure that your procedure is on point, your severance pay in cases of redundancy is on point. The thing that I'm saying right now, ladies and gentlemen, is if you are a member of NSSF, any pension fund, any provident fund, you're not supposed to pay service pay unless you have service pay mentioned in your employment contract or your internal regulation policies. Also, if you are a member of a trade union that has been recognized within your employer and they have mentioned how service pay should work, then service pay can be paid in that order. Severance pay is only paid when there is a redundancy. When there is no redundancy, no severance pay. When you finish your employment, what do? You get your certificate of service. If you've dismissed somebody summarily, within 7 days, you're supposed to have paid them their benefits. And each and every other dismissal, the good practice is to make sure that within 2 weeks you've paid, or in the next payment cycle that you have, you've made payments to this particular person. Some contracts have non-compete clauses that says, for instance, when you're in the organization, you're not supposed to compete or do any businesses that are competing with a particular employer. employer, or if you have left, they have given you an embargo of maybe 3 months, 6 months, or not being able to compete with the employer. The key secret here, ladies and gentlemen, is to not randomly add non-compete clauses to contracts. Non-compete clauses should be added where an intellectual right has been created, an intellectual property right has been created, like a copyright, a trademark, a patent. So I'm talking to people who are working in manufacturing, people who are working in drug manufacturing, people who are creating things. You can actually say, you need to be able to hold that knowledge that you have learned from me, all my trade secrets, up until a bit of 3 months for those things to have evolved for that non-compete to work. So if you have a non-compete for a person who's a salesperson and you're telling them they can't work after they leave you for 3 months, that will not be enforceable even in law. So remember, the key is there an intellectual property right that has accrued or has been walked into during the process of employment? If it is none, you will move on from that one. Suing, ladies and gentlemen, please know that a person can sue for unlawful termination for a period of up to 24 months within the time they left. So they can sue you even 1 year after they left. So please remain prepared in all of these things that are regarding employment law. And I hope you've been able to just get a good synopsis of what employment law is in action. I'm seeing our questions have lit up. We are super excited about that. We will answer these questions as we are continuing with the process. I'll ask Judy to take just 5 minutes to walk us through which are the common pitfalls and the mistakes that are made. And then we'll just ask Okech to give us a little bit of the trends within the employment sector, and we will jump then straight into your questions. Judy, asante.
Thank you, Wandi. When you just went through the different buckets or the different points of entry for employees, that now takes us over into the common mistakes that employers have. And this is not an exhaustive list. These are just the common ones because there's a lot, from the minute you start doing medical checks or even, doing recruitment, mistakes can start from there. As Wendy mentioned, preferential hiring. You've not even hired the person, but then you already have done a mistake even before the person comes on board, that is a prospective candidate. So I'll just go through the pitfalls here. And I had mentioned, one of the best practices, we're talking about having policies on discrimination. Then one of the things that, has been seen is that discrimination has been one of the areas where mistakes have been made by employers, discriminating because of, disability, sexes. Nowadays, we just don't have the traditional female, male gender. There's more, and this is where, inclusivity and diversity is coming through. So if, someone says, I'm neither female or male, do you then, discriminate them because of that part? No, I mean, best practice. Times have changed. This is not, the old traditional times where we were in. Things have really moved, to another generation. Discrimination, Wendy talked about pregnancy. As much as you've had a very good CV, the candidate comes through, and the first thing you notice is that they're pregnant. Do you just, shut up and say, oh my goodness, I cannot even go beyond this interview because, this lady or mother-to-be is going to have a child and then go for maternity for 3 months, and companies that have best practices have even more than 3 months with annual leave. So, you can imagine sitting in an interview where the line manager or the employer is looking at that bit of offering a job to this fantastic candidate, but then they're looking at the negativity of it. That's discrimination right there. I've sat in interviews where, someone just throws in a question and says, are you married? And you're like, what does that have to do with anything, or where do you live? You can ask that if, working in a place where it's like almost like in the desert, just to see whether the person lives in the vicinity or then you need to provide transport for them. But if that question has nothing to do with the job that they're going to do, then you'll be putting in yourself into a mistake of discrimination. Failure to have policies on matters like sexual harassment, and that is put in very well in the Employment Act. And one of the things that most companies often forget is having a sexual harassment policy, especially if you have more than 10 employees then working for you. The act is clearly stipulating you need to have a policy, and what processes will be guiding that policy. Someone is, alleged to have done sexual harassment. How do you go about it? And then the employees need to know, I need to know there's a sexual harassment policy so that, and you've heard of stories where, people go for a party, end of year party, this was before COVID hit us, and, things happen at the party. Then you wonder, do we bring a litigation because people were not themselves, those kind of things, and it's sexual harassment. Have a policy that will guide you to avoid those mistakes. And then mismanagement of casual workers, very common. And this is where, Wanda was referring to having third party, seconding employees to your organization. And that's where outsource comes into play. And there are many organizations in Kenya that are doing that, offering that service, so that you don't have liability over these employees who are casual workers. Failure to protect wages as per the law. We often hear of organizations that just going to deducting pay. Judy took a bite of deduct that from their pay. Is that legal or not? How are you paying? Are you doing for the casual workers? Are you paying as per the wages order? Are you using the Nairobi rates as opposed to the Machakos rates? Because they're usually rates that are categorized to the different counties. So those are that's an area where common mistakes come through. Undefined or inconsistent leave forfeiture procedures. This is one of those common ones. And I know a number of companies where, leave forfeiture, you're given 10 leave carryover to the following year. And there's a conversation, and we'll talk about this during the Q&A, of how leave forfeiture procedures should be managed. Lack of adherence of legal and internal policies on suspension. So I talked about best practice having grievance policies and disciplinary policies, and also the administration of the same. So this is an area where common mistakes come through, having lack of that. Unreasonable redeployment procedures. So this is where you have, and especially in companies that have branches all over the country or outside Kenya. So how do you just, wake up one day and say, Chris, tomorrow you're going to Kisumu, and then next week you wake up again and say, we're sending you to Mombasa. So even before you settle in, and there's, in the pocket guide, there's explanation about the same, about a case law of that, a scenario case that happened on the same. Conducting involuntary separation can be classified as unlawful termination. And this is where we are told as best practice, have employees consenting to separation. There's mutual separation. And one of the things that are, talking to various HR professionals, they ask, is there voluntary separation? And there is from best practice. It's not from the law, but best practice says, we sit down with Chris and say, this is not working. Let's separate. Maybe it's because of medical grounds, because maybe, there's the things, our relationship is not working well. You can have mutual separation. You have consent and right of the same and agreement the same. On the other one is the failure to document process, involuntary termination. I often advise that when you're having voluntary termination, so this is where you have early retirement. Everyone is happy, they're getting a package. Well, most of them are. But then you forget to have documentation. What happens? And the reason why HR usually have files and they keep them for a while is that, I'll move from this organization, go to the other. So if I did not document that I paid Chris during, there was a voluntary termination and Chris signed off, then Chris can come and say, I never got this money. So the purposes of having documentation and filing them is not for the purposes of it's a good to have. It's actually for protecting the person who has been given the dues upon termination, voluntary termination, and also the same for the employer. So you don't have future, conversations of the same. I never got paid, I never got my money, and then it becomes a whole rough, conversation about, whether the money was given or not. And then the other one, my second last one I have here on the slide is failure to adhere to law and policy in redundancy. So here, and we saw this last year when COVID came and hit and everyone went crazy. No one knew what was happening. The employer, the employees, the senior leaders, lawyers, everyone was caught up in this. Okay, do we do redundancy? We don't know what's happened. This COVID, don't know whether it is gonna end or not. Is it the end of the world? At some point, people think it's the end of the world. Then what is the law saying about redundancies? Are you paying within the requirement of the law, 15 days of every year worked? Best practice goes even beyond 15 days of every year worked. And also on the same redundancy, are you going through the process? Is it LIFO or are you doing FILO? Is it, people who are skilled, you're letting them go, and then the ones who are not skilled, you're leaving them behind? So that fair process on the same should be given to avoid these common pitfalls. And then the last one there we have is adhering to paying wages upon remuneration. So if you don't follow what the law prescribes in terms of paying wages, is it within the minimum requirements? Are you paying, and then deducting? And this is common in some industry. I don't want to mention the industry, that you're given PPEs and then now it's deducted from you. That's not right. When you're giving PPE, it's to protect me, and the OSHA's Act actually defines that the employer has they have to provide PPEs. So why are you then deducting it from my payslip? So just going into that to avoid those mistakes and pitfalls that I say, this is not the entire list. There's a lot of things that we can avoid employers from having these mistakes. And I always say, even before you go into these pitfalls, have conversations, for the same. The other day I saw somewhere that, there's an employee who wanted to sue the company. They're still working in the company. And is that wrong? No, it's not wrong. So maybe they're exposed to, they're working in a factory and they're being exposed to, death or injury. Then they're supposed to raise up their concerns and say, I am, I'm worried about I'll lose my finger if I continue working here, or I'll be, I'll lose a limb or so, or my eyes will, I'll not see, or I'll never be able to breathe again because of the toxic matters that we are, manufacturing. Then, to avoid that, have conversations with employees. I say you're also employees, whether you're a line manager, whether you're the senior leader, still an employee. So just having those conversations to avoid those common pitfalls. Right. So I'll pass it over to Chris.
Yeah. The next section now is on new trends and areas and new developments. And as per our slide, the first one is the Employment Amendment Act. Now, the Employment Amendment Act came into effect on 15th April 2021. And it only thing that it introduces is the issue about adoption and leave for in a situation where an employee adopts. Now, this right is allowed so that the employee can welcome the new child to the environment and get accustomed to that new relationship. And the employee is entitled to 1 full month's paid leave. And the only precondition that is required before you can actually qualify for this this right is that 14 days or so before, at least 14, a minimum of 14 days before you get the placement of the child in your residence or at your home, you need to have given your employer at least all the documentation and paperwork supporting the adoption. Yeah. So yes, that's the first one. Now, the second new area that is coming up is the Data Protection Act. And on this one, I remember my colleague Wendy here had actually expressed it, discussed it quite at length. But the basic requirement is that under the Constitution, employees have a right, yes, both in public and private sector, to have their information protected. And this is actually premised on the section 31, Article 31, C and D of the Constitution. And actually now the entire Data Protection Act is actually just there to enforce and further expound on this right. Now, the next item is the National Housing Fund. And the National Housing Fund is actually there as a consequence of the enactment of the Finance Act of 2018, which was signed into law on 21st September 2018. And it at section 85, I'm sorry to be so legalese here, but under section 85, the Finance Act amended the Employment Act to introduce an employer and employee contribution to the National Development Fund. And under the Act, it essentially required that an employee, each employee actually have a cumulative contribution of 3%, 1% coming from the employee's personal salary, and the other 1.5% coming from a total contribution from the employer. And this is actually it was all pegged to a maximum of 5,000 shillings, a contribution, so that the entire 3% should not be more than 5,000 shillings. The implementation of the levy actually remained a bit, it remains still part of a contentious court case, because there are issues around how the government can be accountable for these things. What happens if you get terminated in the middle, and then, so there was a lot of issues surrounding it. And until at the moment as we are talking, the section still remains because it is subject to a court process. Now, the next issue is, which I've seen a lot even in the question and answers, is non-compete clauses. Non-compete clauses are actually very commonplace in innovation and creative sectors. We have to note that it is very, very specific to particular sectors where it is felt that there is innovative information or extensive training and specialized training that an employer has to go into to get their employees up to date. So essentially, it is allowed and enforceable where, example, one company has innovative information that if the employee was to run away with it and to go to the competitor, would cause the company great loss. And also in situations where an employer spends a lot of resource and time and money, especially, to train its employees. So the non-compete clauses actually apply to very, very specific situations. And because also it has to be considered that this right is very, very sparingly usually enforced, because there's also a corresponding right for an employee to leave employment, given because there's usually notice requirements in contracts. There's the rights that you have to, fair practices. Of course, in the event that your work environment becomes a bit unfriendly and there's a bonding or a non-compete clause, what happens to you then? Because now, again, it now means that you cannot actually get an employment contract. So it is one of those areas that is very, very specifically enforced, and it has to be, the conditions under enforcing these laws are actually very, very strict. Now, the other item is bonding, and bonding is very closely related to non-complete complete causes. And this is really because, again, as you know, when an employer spends a considerable amount of resource to train you and whatever, they have a right to actually recoup the investment, so to speak. So in that situation, and it's actually very common, even government does it. The armed forces, they do it in situations where they train people and stuff. Now, the other new area of law, which is a newer trend, is working from home. It is not in the slides, but it's an area that is more and more becoming very, very popular. And especially because of the effects of COVID-19 and the requirements for social distancing. So which means that in many cases, not every employee can be at the office, especially for big companies. If you look at banks, which sometimes have, a pool where HR would have 30, 40 people seated very, very close to each other. So that the requirement for social distancing would actually now mean that it would be very impractical. It's either the office, the company goes and rents a lot of space, which is, of course, now again, not very economically viable. So because of this, we are now seeing a trend where now we are embracing working from home. There's now technology, there's remote working, there's Zoom meetings, which are very common. Even look at this forum right now. Before COVID, probably ideally would have all sat in one room somewhere and then gone through the training, and of course now, which is impractical. Now the positives of this working from home is there is improved work-life balance, because now you can work in the house, you can watch over your little babies and stuff. There is more and increased employee engagement. Now everybody usually has a voice, because before, where some people just want to keep their heads down and then go unnoticed, you show up, clock in, do your work, leave. Now you have to now talk to your colleagues and talk to your employers, contribute, and it's actually fostering a situation where people are more open and outspoken about their ideas, which is actually very good. Now the other advantage is there's fewer distractions when people are working from home, as compared to the office, where you have to get up, walk to the dispenser, walk over to a meeting in HR, there's another phone call, there's that gossip at lunch break over small recurrent issues. Now, there's also the other thing that we know. Nairobi is actually one of those areas that has probably the worst traffic in Africa. This is not a fact, of course. It is just from my personal experience. I believe it's actually terrible. So there's actually a lot of time that is spared because you don't now have to wake up and commute. And you see, even for you guys, I'm sure most of you guys, this waking up and just having to take a shower and sit in your dining room and now work, you have. The environment is friendly. So you actually end up being more productive. Now the trick here is so there are some situations and some sectors which it is actually a bit difficult to enact this working from home. So it is one of those things that now again each organization has to now look at what its requirements are, what is the deems necessary, because now sometimes you have to now go into the provision of providing computers with extra security, paying for internet, or making sure each of the employees has internet. Of course, now again positively, which now means that sometimes organization can save on space, because now there's this hot desk system where you have a pool where people come, you plug in, you do your work, and you leave. Which means now, at least because now people are working in shifts and stuff, which means especially for banks, I can give an example for a bank. I know some banks actually working in a way that half the employees are coming on 1 week, then the other week it's the other half, then the other week is the other half. So it's actually a very, very good system. Now, other than that, actually, that's the last trend. And now we will hand over to Wandy and maybe our convener, Josephine, to take us now to the question and answer sessions. I'm actually seeing very, very nice questions here, and I'm looking forward to that most engaging phase of this webinar.
Amazing people. I'm just absolutely loving the questions that are coming in. We have taken some time to answer some of them. Some of them we are very busy right now trying to work towards organizing how we are able to answer these questions. What I will do is I will just run through some of these questions and I'll pass some of them to my colleagues. Most of them are being answered on the chat. So please read the chat. So please read the chat, and then we will be able to see how to answer from that. Sorry, I'm seeing that we have, I'm just trying to do a time check. We are doing a time check to just see how well we are doing with time, so that we can be able to know how to proceed. So we have quite a good timing, almost an hour towards answering questions and answers. But before I answer this, I just want to set one record clear before we even pass this to any person. There is this conversation between the Regulation of Wages General Order and the Employment Act. And people have been asking continuously, has this order been repealed? Should I follow it? Should I not follow it? And all these things. Let me give you a small history of how the Regulation of Wages General Order comes into play. This is an act, this is an order that has arisen from what we call the Labor Institutions Act. So the Labor Institutions Act goes out of its way to explain how labor institutions should relate. Among the purposes and the mandate of that act is the creation of a wages council, both general and specific to the different sectors within the country. Now, this particular wages order came from our previous conditions of work, minimum regulations and conditions of work act that was repealed. However, if you read the Labor Institutions Act, you will notice in section 63, it says, yes, these things have been repealed, but in section 63, subsection 2, it says very clearly that any of the orders that were made under that particular act will be looked like orders that have been made under the new act. So that means the regulation of wages general order is law by virtue of section 62 subsection 2, section 63 subsection 2 of the Labor Institutions Act. Now, how do we operationalize it? We operationalize it to this extent. Any provision that is in that order that is in conflict with the Employment Act, the Employment Act will rise supreme. So let me answer what in conflict is. When in the regulation of wages general order, it says that a woman shall be entitled to maternity leave at a rate of 2 months, it becomes in conflict with the Employment Act because the Employment Act prescribes for a minimum of 3 months. So we go with the minimum that is the Employment Act. Now, where in situations is it not in conflict? This is the all-time question on sick leave. The Employment Act says that you are entitled to a minimum of 7 days of sick leave with full pay and 7 days of sick leave with half pay. The words used there are a minimum. If you read the regulation of wages general order, it says up to a maximum of 30 days of 30 days with full pay and 15 days with half pay. So there is really no conflict there. You can follow the minimum and give 7, or you could as well go ahead and give the maximum, which is 30 and 15 in reverse. So this is a question that has been asked a lot of times, but this is how you should be able to generally interpret this type of question when it comes to you. So now let's look at the different questions that we have. We have answered quite a few. The others we will also answer as we are continuing. At this point, I will ask Josephine to start looking at all the questions that are coming in and start organizing them for us, as I just now plan to talk about the different questions that are currently here. Caroline Waivukia, you have asked us about non-compete clauses, and I think this has been answered by Okech very well. Unless you have something that you didn't understand, you can reach to us and we can be able to explain. Josephine, please type on the questions that have been answered, that they have been answered, so that they can move out from the question and answer panel. Emily Kinuthia is asking, what is the best practice when it comes to remuneration packages? Is it fair for an employer to give a lower salary to an employee if they are not aware of the package or level or band levels, or should the employer disclose this to the employee? Judy, I should ask you to take that one. I'll read the second one through. If you have sourced, this is from Jacinta Kisungu, if you have sourced for employees for a vaccine and they refuse to be vaccinated, is it within the law to write to them that the company will not cover medical bills in the event that they contract the virus? So, okay, I'll let you take that one. So, Judy, you can just answer Emily, you can answer Jacinta as we continue.
Right, thank you, Wendy. So I'll just go into Emily's question. I'm just going to Emily's question, which has
the Jacinta Kizungu question, if I can just help with Judy.
Yeah.
Not Jacinta, the Emily question.
It just disappeared from the screen.
Yes, so she's wondering, is it best practice to hire and pay different salaries, even if there is a salary band in the organization?
Yes, so different companies have different practices. I've worked for an organization where remuneration was transparent. So you know you're in grade L. This is the bandwidth of grade L. So there's the entry position, there's the mid, and then there's the seasoned, which is called the mature, so the max. So some companies will be very transparent and say for L, as a sales representative, this is your band. So you get between 10,000 and 30,000, for example. So you know where you fall in. Some companies do not disclose that, and it's as per the company policies. They will only tell you are in, there are 5 grades, A, B, C, D, E, and then they say you fall in one of those ones. For best practice, and it's conversations that go, within the senior leadership and HR. Why, when it comes to being transparent on the same, what is the secret beauty of not having awareness on the, the different bands? Because for me, it will be prudent for employees to know where they're sitting, the salary ranges. Sometimes you're not given the details of where you sit, whether it's entry or mid or etc., but you can tell from where your salary sits in that you're either, if it's 10, it's entry, if it's 20, it's mid, it's 30, it's then maximum. Then also that will help you as an individual to know, I'm sitting at entry level. So what do I need to do to get into the mid level? Use your performance, performance management processes and say, I have a gap in this area, or I'm good in this area, so I think I should be at mid or at max. So it depends from company to company, but best practice from where I sit, transparency is usually better. Yeah, but it doesn't have to go into the real details that someone is getting 10.3, 4, 5, 6, 7 to, to the point. So I hope I've answered you, Emily, on that one. When did you want me to see the other one?
Yes, okay, you can just speak to Jacinta in terms of vaccines and the company refusing to pay for any infections afterwards.
Now, as we all know that most insurance companies have, and most policies that most companies take, have this caveat that pandemics are not covered under the insurance policy, which means ideally that in case you contract COVID, most likely than not, it's either you're going to have to go into your pocket to cover these costs, or your employer is going to have to do that. Now, this issue is still out for debate. There's actually no specific law guiding this. So it is more of a case-to-case situation. And the most compelling reasons that employers have to request that the employees get the test is actually just because in case you get unwell, your insurance company will not cover. So for that reason, it is one of those areas that we cannot say with authority. And we are the jury is still out on this one, so we'll have to wait and see. But remember, your insurance company might not cover you in case you get unwell. So it is good to confirm.
All right. If I could just add on that particular question, the other thing is to consider best practice. I know a lot of organizations have gone out of the way to find these vaccines for people, but some of the people are just not comfortable to take these vaccines. You should be able to accommodate people, especially with divergent views, yeah? So again, best practice, just look and see which is the best way to handle this thing. When telling somebody something like, do not, what is the word? You are not allowed, if you get sick, we won't pay for you. It will cause a bit of strain when it comes to working relationships as you are going forward. Ladies and gentlemen, I'd like at this point to seek your indulgence to give us another maybe 20 minutes as we are going through answering these questions because they are a lot. I will go and quickly rush through some of your questions so that you can allow people to also speak, because I'm seeing hands have been raised up. So on the issue of an anonymous, somebody has asked us, would you hold a sales representative's final dues after termination on grounds of performance where he or she has accrued customer debt in their accounts which is more than their final dues? Again, I'd like to remind you that when dues fall due, you are supposed to pay them. You are not supposed to withhold them. Any employer who unlawfully withholds pay is actually liable to an offense, and it has an amount that you will pay towards it. If you want to make deductions, you can make deductions, but not more than 2/3 of the payslip total amount. If this is still with less than what is required for the payment of the debt, you can pursue the debt through other legal mechanisms other than payroll. Like, for instance, you can send it to court for them to be given an order for you to go and collect it from them directly or attach their properties, etc. But do not withhold an employee's pay. Is leave forfeiture allowed in the process? Is leave forfeiture allowed, and what is the process, and is this legally sound? Leave forfeiture is a very tricky issue. At least you can see from the Employment Act, it says very clearly that after 18 months, somebody should be able to forfeit the days. When it comes to people who have given only the 21 days, it is important to look and see that you are at least giving them the 18 months before you start talking about forfeiting those days. Make sure that you're also speaking to them and telling them in advance that we shall be forfeiting those days. Don't just wake up one morning and start saying we have forfeited the days because they are past the 18 months due date. The other thing that you should remember for those people who are giving enhanced provisions, like now you're giving maybe 24 days or you're giving 30 days, you're not really put into that bracket of 18 months. You can actually create your own policy and see how we can be able to handle this. Now, there is a question from an anonymous person that says, should gaps in employment history make a candidate not be qualified for a position, even if they're most qualified? Now, that's not a legal issue, that's a HR issue, and it becomes more how you are working towards how should I call it? It depends with how the candidate has presented themselves and the values and trusts that the organization has particular issues in that case. Now, I will get Judy to take this next question. How do you deal with two employee personal issues that one defrauded another? Can this be a disciplinary issue if brought to HR's attention as breach of trust and affecting co-workers' relationship? We'll go the next one. Okech will take it in regards to maternity leave. If an employee is advised by the doctor to be on bed rest for a couple of months, should this be considered as sick leave or unpaid leave? So, Judy.
Thank you, Wendy. So I'm laughing because on the issue that the person has been asked, and I'm laughing because I've had experienced that before. When two employees have had issues or concerns, which distracts their relationship, then definitely it will affect how they're performing. You can imagine if I had a conflict with Wendy and you're working in the same department, what will that mean to our productivity for the day? Something maybe we're supposed to do a project together, it's not working because I gave Wendy my money, or I lended them my money, and then they're not repaying us for what we had agreed, and now our friendship has just been, has gone to the drains. So I think for me, this is not a way. There's no law that talks about the employment law, or the international labor law. So this goes down to company policies, and I think for me, what I would ask is have raise that issue to your HR or to your senior leaders. And talk about the issue, and then because it will be affecting your work for sure. You can imagine if you meet across, the corridors, in the washroom, in coffee area, then what does that mean? So I think that issue should be addressed in a very mature manner. Raise it with the relevant leaders, they're not part of that story. When you're lending money with each other, they're not part of that story. But then if it's affecting your work, then definitely raise it up and say, this is the reason why I cannot be in the same project with Wendy because this and this happened. But those matters, and also seek maturity as you go into our workplaces, that you don't carry things like those ones that will affect our performance, because at the end of the day, people have different eyes of looking at the whole situation. You might just get yourself into a disciplinary issue, which you did not intend to get into. Yeah, so you can raise that concern with your HR, and it's purely for the purposes affecting your performance. Thank you.
Hi, on the question about sick leave and bed rest. Now, the Employment Act, actually, an employee is allowed to up to 30 days of full paid leave. And then after that, a maximum of another 15 days on half pay. Any rest that is over and above this period of 45 days, it'll become unpaid leave. Of course, maternity will not be touched because that is a different right. So bed rest is actually considered like just regular sick leave.
Josephine, at this point, I would like you to just allow the people who've raised their hands to speak to us.
So I have allowed Cecilia Kerubo to shoot her question. Kindly, Cecilia, go ahead.
Hello, everyone.
Hi.
My input was just my suggestion for best practice when it comes to the COVID issue. So as a HR and as you advise your employer, given that maybe you are not able to manage the cost that comes with the COVID cases that you may incur in your organization, you can go over now and allow for a maximum of a number of days, so that then you're saying you're allowing your employees, in the event that they contract COVID, a number of days in a year as a support for your employee, and not mention maybe the cost that comes with it, given that most insurance don't cover. So you can just go ahead and say, as a company, we are cognizant of the situation, and our policy on this will be, we will allow everyone a maximum of this number of days in the event that you incur or you get COVID, and then on return, definitely maybe a certificate to show that you're fit to come back to work.
Thank you.
Wandera, do you have a response to that? I know it's a statement before I allow the next person to ask their question.
No, actually, we are just very grateful to Cecilia for the comments. We appreciate.
Great. Jane Gishuru, the floor is yours.
Good morning, team. Thank you for the opportunity. I hope you can hear me clearly. My concern was just on what Mr. Okech has just spoken about, the sick leave. Our employee has been given bed rest. Maybe he can clarify, because I didn't hear him very clearly. And in the event such stipulation, or maybe when the employment contract only the minimum as per the requirements of the Employment Act, I would want to know how we would handle that in case it's not stated in the employment contract. Thank you.
Chris, over to you.
Allow me to take it for Okech. It seems like he lost Jen at some point. So Jen, the thing that you need to be aware of is that when a person has produced a medical certificate that shows that the person is unable to attend work, that person is considered immediately to be on sick leave. Whether or not it is included in your employment contract, the law says that this person should be allowed a minimum of 7 days. But if those 7 days with full pay and 7 days with half pay. But if that sick period extends past that, we go towards the maximum provision, which is 30 days with full pay and 15 days with half pay. If it exceeds that maximum provision, then you can be able to see if internally you can have mechanisms where you can speak and organize for the person to remain in the organization, or you can work towards a dismissal of that particular employee on medical grounds. But I always advise employers to be very sensitive, especially to employees that have been incapacitated, not for their own doing. That would be my best response to that.
Great. We do not have any more hands raised. So we can move on to the next question. So I'm going to read it out, and then Wendy will take over from the Q&A session. From anonymous attendee on matters termination of probationary contracts. What exactly does it mean that there is no option for administrative action prior to the termination of a probationary contract?
Come again, Josephine.
On matters termination of probationary contracts, what exactly does it mean that there is no option for administrative action prior to the termination of a probationary contract?
All right, I'll take that one. So on matters probation, the law currently had provided that probation contract can be terminated by giving a 7-day notice. Best practice is to make sure that before you give that 7-day notice, you have actually gone through a performance appraisal process where you have told the person that, hey, this is how we feel you're performing, you are not improving. I always say that it is also very important to follow forward and maybe put them on a PIP after that. If they don't work well, then you can dismiss them with notice on matters of on basis of performance. I know currently in law, the principle is that a person can only sue for unlawful termination if they have completed 13 months of employment. However, there is case law that actually says that provision deprives a person of their legal rights and has allowed for people to sue for unlawful termination within any point of their employment. So again, we just need to be consistent with best practice so that we can avoid litigation. And also we have to remember we are dealing with human beings. So putting human into that process is very good. So try as much as possible to be accommodative to the most that you can be. Thank you, Josephine.
Thank you. Perhaps Judy, you can take this one is in regard to maternity leave. And the question from Robinson Bosire is, how do we handle stillbirth?
Thank you, Robinson. The issues about maternity leave, and I'm happy to just mention now that there is a bill that was passed for pre-adoptive leave. So when it comes to stillbirth, this is where best practice comes in again. What policies do you have in your organization that deals with such? Because we cannot always assume that, you know, the pregnancy will be full-time, there will be a baby, the person will go for maternity leave. So when it comes to stillbirth, then, you know, the company now has its policy that say in case of, you know, a stillbirth, then we give the mother this number of days. It can be the full 3 months if the baby was there. So that's good practice. Some organizations will have a policy of saying that we'll give 2 months or 1 month, but then also that should be collaborated with the situation of the mother, because you can imagine you've carried your baby full time and then the baby is not there. You can imagine for those who've gone through that encounter, it's, you know, if you hear the baby crying, you don't know what, you know, there's some mental, emotional things happening. So it should be a very candid conversation with HR. If the policy says, your company policy says 2 months, if you have stillbirth, you come to work. But after those 2 months, the mother is not ready to come to work because of the emotions they're going through, then there can be a conversation, you know, just saying we'll add you another additional month, which can be taken as sick leave or whatever policy is there to be able to support this mother. So I think I have answered well, but this goes back to best practice again. Thank you.
Thank you, Judy. Just to let you know that because of the limited time, we are trying to answer some of the questions in writing. So kindly check on the answered questions if your question has been answered, as we also try to answer the others in person. So this one goes to Chris from Elizabeth Gilani. How do employers ensure they are legally bound or protected with occupational health and safety during remote working, that is working from home? Do we have a say in workspace and hazards while at home?
Yes, on this one, it is still, mostly an issue of there's no control of the employer when you're in your own residence. Yeah. So it is expected that provided they've given you, especially if you have an insurance cover. So I don't think there's no action per se yet to actually clarify that issue. So more or less, I think the most an employer is required to do is maybe provide for your a medical cover, or if they're paying in your NHIF. So I don't know. I believe because it's in your home, it's one of those tricky ones, because they cannot really come to your house and start enforcing, giving you helmets or whatever, because it's expected nothing in your house is going to fall. This is actually mostly where you have to work in a factory or in an office setting where the employer has full control of the situation.
Allow me to add in just to that answer, and I'm going again to best practice. And I know a few companies that went beyond, when COVID came and they're working from home, from the occupational side of things, because if you've talked to your friends or your family or even yourself, there's been Zoom call after another Zoom call. By the time you realize from 8 to 6, you're just seated there stagnated. Best practice, we have some companies that actually provided, seats and sitting space for their employees. Chris talked about, the shared working spaces, and I got to see one somewhere in Westlands, where if you don't have a working space from home, because maybe I'm married, I live in a 1-bedroom house, we are all in there. How do I work in that space? I have a small child who you cannot control, crying all the time. Then some companies have gone beyond looking, saying that you need to work from home by providing that space, the shared working space where you can go and work, and they provide Wi-Fi and ensure, the shared working spaces have good seats and all that. Some have provided seats that, are good for your back. But there's a debate also still going on on the OSHAs, how do you then, 10 years later after this COVID happened, can I go and sue my company and say I got this neck pains because I used to work from 8 to 6 p.m. doing Zoom calls, just, doing my work, and I was working from home. So it's something that the OSHAs also will guide on the same, and then see how best to address those issues. Thank you.
Thank you both for your elaborate responses. Allow me to allow Dixon Nyambori to ask their question as they have raised their hands.
Yeah, thank you guys. I think my question is addressed to, I think Wendy is the one who talked about the stillbirth issue. If not Wendy, anybody can answer. The question is, we give maternity leave not because only of the child, but also because of the mother recovery and being able to get back to her position before pregnancy. The law has allowed me to get the pregnancy, and I've gone full term and there's a stillbirth, which means I was just about to proceed. I've even applied for the maternity leave. What right does the employer have to deny me the maternity leave based on the fact that it is not only for having the child, but also for the mother's recovery? And losing the child, ladies in the room, it is not a walk in the park. It would be good if it is, from what I've done in my place, is we've given it as a way of the mother making that decision. Because legally they can challenge you and say, it was not just about having the baby, it's about also my recovery back to my normal body function. That's number one. Number two, it is, I've carried the baby full term. It would be good if we give that conversation back to the lady and say, if you feel that recovery for you would be you coming back in 2 months, that's okay. But you have your 3 months to decide. Beyond the 3 months, then it becomes sick leave. That is how I've structured it in my current organization. Thank you.
Thank you for that particular question and statements that have followed, because one of the things that I have really appreciated is that in your organization, you have gone out of your way to include humanity into the process, because legally the requirement that you have is to give a mother that has had a child, because actually that is said in the law, when you've had a child, to have the 90 days of maternity leave. Many organizations that are very strict require, in the event of a stillbirth, for a mother to go to hospital, get treated, get the normal sick off, stay home, get well, and then come back to the institution, which is very difficult for a person to handle as a human being. I'm really very grateful that in your organization, you have taken time to bring humanity back into this process and say, hey, you can finish your 90 days at home. That is really amazing. Thank you very much.
Ayoti Bukachi. Kindly let's now keep the questions and the responses also as brief as possible, as we are running out of our extended time, and we appreciate your patience with us.
Thank you very much. Great presentations. I posted a question. I just thought maybe I'll just raise my hand and ask it. It's about how we are managing internships or trainee programs at the workplace, because I've recently been doing a research and I just found that ideally an intern is not regarded as an employee. And so therefore, if you've given an internship contract, sorry, can you hear me?
We lost you for a second.
Okay, sorry, yes. So I was saying that an intern is not regarded as an employee because it's not, basically, this is supposed to be treated outside the employment law. But in many cases, and in my previous practice, we've always given internship sort of employment contracts. We give them leave days and basically pay them not a stipend, but like an entry level salary, which is taxed. And obviously with the pay as you earn, then you're basically regarding this person as an employee. And so I'm a bit confused now because my recent research tells me that an intern is not an employee. So I'd like to know, how should this be structured? Is it under contractual law? And then is this engagement supposed to be outside and more or less regarded to like how you'd relate to a consultancy contract? Thank you.
Yeah, that's a very good question. I'll take it. Currently, there is no provision or any laws that ask you to treat an intern as an employee. And it's very, very clear that an intern is not an employee. So one thing that I've always advised organizations is to work with best practice. Thing number one, do not be that organization who sends out a job description that says the person responsible for the sales of the organization meet quarterly budgets, give projections, etc. And this person is an intern. If you are doing that, stop that. Make sure that you're actually putting through a program where this intern is learning something. Make them become an understudy of a person, and through that create a contract that is more of the training that particular employee, and then treat them with dignity. And if this thing goes out and somebody sues you, for instance, we will simply go back into the law of contract, and that's how it will be treated. But best practice, make sure that the intern is actually learning something, they are placed under a program and somebody who is observing them, and that the period of internship is not unnecessarily long. 3 months for me is maximum for internships. If you're going to do 1 year, then call it a management trainee program or an apprenticeship program. Do not say that it is an internship. Thank you.
And just to add on to Wendy, one of the things I've also learned is that different companies have different ways of describing interns. So you go to a different company, they say an intern is almost like an assistant. An intern should be someone who's coming to actually study. So they're not employees per se, but going again to best practice, you can give a stipend. You can do have an insurance cover for them for that period where they're coming to learn for themselves. So also the definition of internship, I think we should be careful when we are coming up with our policy. So that is very clear. An intern is a student who's still in school during the 3-month break, they're coming to offer or learn their services. And when I say they're coming to offer their services, it's maybe they're coming to do a technical kind of thing. So that we also clear with those definitions, internship, assistant, apprenticeship, what does that mean? So that the policy will guide you very clear and say an intern is a student who's coming for this period, and once that period is over, then they go back to school. Some call interns after they graduate, they still call those students interns, but it should be, you should be having maybe for best practice as a graduate program, because they finish school and they're looking for exposure into an entry position just to learn from theory now coming into the work experience. So let's also be very careful on how we have those terms defined in our policies. Thank you.
Thank you. All these questions will be answered in a pocket guide that we have prepared in detail, and that shall be shared via your registration emails after this. Perhaps you can take this tune together from Beatrice Sapuro. Is it legal for an employer to revisit a disciplinary case that had been dealt with and concluded by a previous discipline manager, but new discipline manager revives and overturns the previous decision made on the case? This can go with, in case of termination or notice, what's the process, especially when dealing with sales representatives in the field?
In fact, I'll deal with that question as I answer another one on constructive dismissal. The one thing about disciplinary processes is that they are generally very emotionally heavy for an employee. And when a disciplinary process has gone on, concluded, and it has been closed, it should be left at that. If you go back and relook into that issue, founded on law, the principle says somebody cannot be prosecuted or looked into an offense more than once. So if something has been done, adjudicated, closed, it shouldn't be open again. The second thing, Justin, was? Jocelyn?
Sorry, the second question was, I think, about in case of termination or notice, what the process, especially with dealing with sales representatives in the field, is like.
Yes, so sales or non-sales or whatever, the point is this. The disciplinary process is a very simple process that goes on. It has been explained for you very clearly in your pocket takeaway notes. But what you should know is this. Once there's been an allegation that has been put in place, if that allegation cannot be easily explained, you need to send somebody what we call a request for an explanation. But currently people are using the word show cause notice. I find that to be so legal, so I just prefer to say request for explanation. When this person gives you an explanation, you can go through the explanation and see whether the explanation has been satisfactory or not. If it is satisfactory, you can close the matter in writing and say, hey, thank you, your explanation was satisfactory, we are moving forward. If it's not satisfactory, you invite them for a disciplinary hearing, and then you tell them, this is the offense that this is the issue that you have had. We've read your explanation. We find it not sufficient. Please note, this is a category, which type of employment, of misconduct. Is it, this can be termed as gross misconduct, or this is, our policies term it as gross misconduct, or this is just misconduct. So in this case, we are talking about this is just misconduct. So we tell you, come in for a disciplinary hearing. You're allowed to bring in your representative, but please be informed that this, the repercussions of this could be up to and including termination. So the guy comes in, you do your meetings, etc. You finish, make sure minutes are taken for the meeting and assigned. Don't give a decision during the discussion. Take some time, consider, come back, give your decision, and then we proceed with the decision that has been given. So in this case, you said you're terminating you with notice. So of course you give the decision in writing, allow for 7 days for this person to appeal. If they don't appeal, give now the letter of termination following the process, and then they will be able to give the payments. So you give the 1 month notice if it's 1 month, 2 months notice, leave days accrued, pay to the last working day, certificate of service, then this person goes. The reason I wanted to take this question with one that has been asked here on constructive dismissal is that there is currently Kenyans are going through a lot of constructive dismissals, and people are going to court and they are losing on this matter. One thing to note is that constructive dismissal is not written in the Employment Act, but it is founded on case law. Case law is very clear on what constructive dismissal is. It gives you the ingredients that make something a constructive dismissal. The first thing is the employer has to create a situation that is so untenable for an employee that the employee thinks that the best thing for them to do is to leave employment. Then the employee needs to have actually left employment following that particular issue. The time that the employee left the employment should not be unreasonably long from the time the environment was created that it was untenable. And then this can be a constructive dismissal. So what the employee will be saying is, I really didn't want to resign. You just made me resign. And the courts have held consistently that this can be considered as constructive dismissal. And of course, you can get the damages, the payments are either 12 months in full, or they can actually be reinstated back to employment, but that's very rare. Yes, Joseph.
Thank you very much. So many questions, guys, and our time is unfortunately not on our side. What we will do is that we'll be sharing that pocket guide to via your emails. In case we did not get the time to respond to your question, do feel free to reach out to us via email, info@conversationswithwandy.org. We will also be on social media at Conversations with Wandy on Facebook and on LinkedIn. We are also on Instagram and Twitter, as well as on YouTube. This session has been recorded live on Facebook, and we will also share the recording via your emails. If there is no any other, and I'm hoping there is no any other pressing matter, of which if there is, kindly reach us via email. We would like to ask Wandy to kindly conclude with a vote of thanks to all our participants. You've been amazing, and I hope to continue engaging on this and on the other upcoming webinars. We hold them on a monthly basis, every Friday or every last Friday of the month. And we just keep tab on social media pages for updates. And once again, thank you. Back to you, Wandy, to conclude and to give a vote of thanks to our panelists and participants. God bless you, and bye-bye from me.
Oh, thank you very much, Judy. I really do appreciate the time that you have taken for us to answer these questions and on best practice. Okay, thank you very much for giving us the legal insight into all of these things. The participants, you have been amazing. The questions have been overflowing. If you have other questions that you feel have not been answered well, just drop us an email at info@conversationswithwandy.org, or you can just chat us up on our social media pages. That's on Facebook, Twitter, LinkedIn. At Conversations with Wandy. Immediately after this, we will be sharing before end of day the pocket-friendly guide to all labor laws. This is a very detailed document, and you will find most of these questions have been answered therein. And I'm sincerely grateful for everybody that has taken their time and extended past their time. If any question has not been answered, we apologize because we've run out of time. But if you still feel very strongly about it, again, just write back to us and we will respond. Please remember that Conversations with Wandy is a process that is just a conversation that tries to enhance the narrative that is within the HR department, one conversation at a time. So all we are trying to do is to simplify everything for us so that we can understand and appreciate HR better. So these webinars are done once every month. They are free of charge. The webinars are done on the last Friday of every month, so you can be able to check and advise your friends to also check. So much love back to you. Thank you, and God bless you. Have a very lovely weekend and a happy Labor Day ahead. Thank you.